Good morning, good afternoon, good day everyone to this celebration of 40 years since the adoption of the African Charter on Human and People's Rights, with a particular emphasis on its contributions to South Africa. We will have some official words of welcome, but let me do some two housekeeping arrangements very briefly. First of all, we apologize that today's event is not simultaneously translated into French. However, I point to you that on Friday this week, we will have a conference, 40 years of the Charter, and that event will be simultaneously translated. So you'll allow me to just say that to our colleagues that may be here from the Francophone world. À nos collègues et participants francophones, nos excuses. Aujourd'hui, malheureusement, nous n'avons pas des interprétations simultanées. Mais veuillez, s'il vous plaît, nous joindre pour une conférence sur la Charte africaine des droits de l'homme et du peuple, 40 ans, qui aura lieu vendredi 2 juillet. Et cet événement sera interprété avec simultanément interprétation. Then we also then ask each of our participants who are here, you are most welcome to, in the chat box, insert your comments and questions. We would like to invite you to be as participatory as possible. We would have a session later on during the event where we will obviously pose some of these questions to the speakers, and where we will also raise maybe some of the comments you made. So, yes, so then I would just also want to note that unfortunately, we have on our program Advocate Bongani Majola, who is the chairperson of the South African Human Rights Commission. Regrettably, Advocate Majola had experienced a death in the family and is unable to join us today. So our thoughts are with him and also with many people out there in our country and the rest of the world who are experiencing tragic loss and some bereavements at this time. So the event today is really linked to the adoption of the African Charter on Human and People's Rights. Sunday, it would be 40 years ago. That was on 27 June 1981. And this event is, as you would see from the program, a collaboration between the Center for Human Rights. Yes, that we have the Center for Human Rights at the University of Pretoria, together with the Human Rights Institute of South Africa, HURISA, and the South African Human Rights Commission. So I ask the first speaker then to take us through the welcoming words, and that is Advocate Pityana. Very briefly about him, he's the Chief Executive Officer of the South African Human Rights Commission. He has worked with the South African Human Rights Commission for many years, some 13 years before he became the CEO. And Tlakula had also left his mark in many ways on the human rights landscape in South Africa as a teacher and as a researcher. So we ask you, Tlakula, please to direct your words of welcome to the participants.
It is definitely a great pleasure for us as a Human Rights Commission to be part of this event to celebrate the 40th anniversary of the African Charter, and also focusing also on the role of the country as well as the Human Rights Commission. I just want to say very quickly that I hope that when Barney writes his book, he will highlight the struggles which the Commission took in order to ensure that South Africa does ratify the African Charter many years ago. And we are very grateful for that. As well, of course, the role which Barney played whilst was the chairperson of the Human Rights Commission as a member of the African Commission. But I also want to emphasize, colleagues, that there is definitely a greater need in our country to support a better African human rights system. And there are still challenges which we have to address. The whole issue of the involvement of South Africa in the African Court, as well as the lack of a tribunal inside that, which would also speak to human rights issues. So I think this anniversary does call for a deeper reflection on us as a country, as individuals and institutions, as to how we can strengthen African human rights system which was basically brought into place through the adoption of the Charter 40 years ago. Thank you.
Thank you very much, Tlakula, for that welcome on behalf of the South African Human Rights Commission. We now turn to Professor Caron Ngoepe, who is the Vice Chancellor and Principal of the University of Pretoria. He served in managerial positions prior to taking his position at UP in January 2019 with the University of the Witwatersrand and with Rhodes. His subject fields are English language and literature, media studies, journalism. And I can sincerely say that since Professor Ngoepe arrived at the University of Pretoria, he found many opportunities to make the University of Pretoria really an African global university. And some people say that Future Africa really has become his second home. Professor Ngoepe, thank you for joining us. And please, we listen to your words of welcome to the participants.
Thank you, Professor Viljoen. Good day and welcome all participants to this historic event. I acknowledge in particular Judge Bernard Ngoepe, the tax ombud. He might actually be stuck in the other connection. So Prof. Viljoen, you might want to send a message to him. Professor Barney, Pityana, seasoned human rights lawyer, theologian, and educator. Advocate Pansy Tlakula, information regulator of South Africa. Advocate Dumisa Nzebeza, newly elected judge of the African Court on Human and People's Rights. Advocate Pityana, Chief Executive Officer, South African Human Rights Commission. Ms. Colette Lohlojane, Executive Director, Human Rights Institute of South Africa, popularly known as HURISA. Ms. Caron Kgomo, Director, Gender and Diversity Management, Department of International Relations and Cooperation. I'm honored to welcome you all to this celebration of 40 years of the African Charter on Human and People's Rights, with a focus on South Africa's contribution. The aim of the event is to celebrate the adoption of the African Charter on 27 June 1981, which was 40 years ago this past Sunday, and to reflect on the contributions of South Africa and South Africans to the African Charter and its application and implementation. This event is the result of a partnership between the Center for Human Rights, Faculty of Law, University of Pretoria, HURISA, and the South African Human Rights Commission. The Center and HURISA enjoy observer status, and the South African Human Rights Commission has affiliate status with the African Commission on Human and People's Rights. The Commission was established in 1987 to monitor states' implementation of the African Charter. It was from 2006 complemented by the African Court. The work of the University of Pretoria Center for Human Rights generally and at this event specifically are closely aligned to the university's commitment to be a leading research intensive university in Africa, recognized for the impact it makes. By presenting postgraduate programs and conducting cutting-edge research on human rights in Africa, the Center invests in the Africa we want, as the African Union Agenda 2063 proclaims. The event is broadcast from UP's Future Africa Institute and campus, a continental transdisciplinary research hub. While we are due to the present circumstances not able to gather and be together in person, we anticipate receiving many of you at Future Africa in the not too distant future. Let me add here that you'll be following on great steps. The former Deputy Chief Justice Tihang Moseneke launched his book, All Rise, from this very facility. Today, we pay and recognize that the legal framework for the promotion and protection of human rights on the African continent that we celebrate today has been put in place by African leaders. We meet as one, President Kenneth Kaunda, one of the last of these founding fathers, and an apologist for African humanism has just passed away. We remember him fondly, together with such African leaders as President Julius Nyerere, Mwalimu, Leopold Sedar Senghor, and Dauda Jawara, who were pivotal in bringing the drafting process of the Charter to a successful end. But today, we also honor South Africans who each has in their own right made or is about to make a telling contribution to ensure that the Charter's lofty ideas were given practical application. Professor Pityana and Advocate Tlakula served as members of the African Commission. They are both giants on the South African legal landscape who brought their Pan-Africanist idealism to the African Commission. We remember the trailblazing role of Judge Ngoepe, who was in 2006 elected as one of the first judges of the African Court. We take this opportunity to congratulate Judge Sebeza for his recent election to the African Court and wish him well for his 6-year term. And we recognize Ms. Caron Kgomo, who was seconded by the South African government to the Commission Secretariat in Banjul for her labor of love in advancing women's rights within the Commission's work. I will leave it to our guests of honor to do the rest of the talking. I trust that this event will not only look at the past, but also chart pathways to a future in which the values and ideals set out in the African Charter are increasingly being realized. Thank you.
Thank you very much, Professor Ngoepe, for those welcoming words and also further contextualizing the event. We now turn to the third partner, HURISA, and specifically the Executive Director, Ms. Colette Letluyane. She has really been a stalwart of human rights activism in South Africa and in the African continent more broadly. She's been working as a human rights defender for longer than 20 years. And she has left a mark, for example, on getting civil society organized within the NGO forum that had played such an important part also within the African Commission's work. Colette, thank you so much for working with us on this event. We turn to you now to give your word of welcome, but also to further elaborate on the context of this event. Thank you.
Thank you very much, Professor. Good morning, everybody. I wish to acknowledge this protocol. Professor Tawana Ngoepe, Professor Barney Pityana, Justice Ntebeza, Advocate Tsidiso Tipanyani, Mrs. Caron Kgomo, all protocol duly observed. Professor, it is really a privilege to have HURISA as a partner with the Center for Human Rights, and we are also grateful for this collaboration with the South Africa Human Rights Commission. This collaboration has existed for many years in promoting the African systems of human rights in South Africa and on the African continent. Today, we are joining hands together as partners to applaud the collective role played by the founding fathers of the African Union, formerly the Organization of African Unity, the OAU, to secure a regional human rights instrument for protecting people's rights on the continent. The regional instrument has made laudable developments in shaping the human rights trajectory of the African continent. These developments began taking shape with the inauguration of the African Commission on Human and People's Rights on 2 November 1987. This was after the African Charter had entered into force on 21 October 1986. This day, 21 October, is celebrated annually as Africa Human Rights Day. Having worked closely with the African Commission, my remarks are focused mostly at the Commission's work. By that time, South Africa was still under apartheid. It was only after 1994 that South Africa started playing a constructive role in advancing human rights on the continent. It acceded to the African Charter in 1996. Professor Barney Pityana was nominated as a member of the African Commission in 1997. Civil society saw this as an avenue to advocate for the African human rights system in South Africa and the region. They gained invaluable expertise participating in Commission's processes, promoting the African Charter. Professor Pityana facilitated NGO involvement by encouraging civil society dialogues to take place before and after sessions of the Commission. These dialogues grew and extended and encouraged CSO networks in Southern Africa more broadly to participate in Commission sessions. These networks contributed to the work of the Commission to protect human rights in Africa, including through their involvement in the Grand Bay Declaration. However, it took the Commission over a decade since its establishment to formalize the involvement of civil society as key partner in promoting human rights. South Africa subsequently also nominated Advocate Pansy Tlakula as a member of the African Commission. The era of Advocate Tlakula was dominated by her role as a special rapporteur on freedom of expression and access to information in Africa. She was able to present a unique atmosphere for civil society within and outside South Africa to promote freedom of expression and access to information in Africa. At this time, the interaction between civil society and key government officials like DERCO, Department of Justice and Constitutional Development, Department of Women, supported the domestic implementation of the African Charter in South Africa. Advocate Tlakula was elected as chairperson of the African Commission in 2015. She was also prominent in promoting the granting of observer status to NGOs working on sexual orientation and gender identity, including sexual minority groups in Africa. South Africa also contributed positively in seconding Mrs. Caron Kgomo to provide technical support to the Special Rapporteur on the rights of women in Africa and to support the African Commission Secretariat. During her time, Mrs. Kgomo engaged in an overhaul of the Secretariat system for registration of human rights statements by state parties, national human rights institutions, and NGOs, which improve interaction with the African Commission during public session. The Commission played an important role in the adoption of a protocol establishing the African Court on Human and People's Rights in 1998. The protocol only entered into force in 2004, and the court came into being in 2006. It should be noted that progress in ensuring effective protection of rights by the court has been thwarted by state reluctance to grant citizens direct access to the court under Article 34.6 of the protocol. Judge Bernard Ngoepe was elected as one of the first 11 judges on the court and served until 2014 and been appointed as Deputy President of the African Court. We are reminded that Justice Ngoepe promoted the advocacy for South African citizens' access to the African Court, particularly during African Commission session held in Angola in 2014. The attendance of Justice Ngoepe concluded with the Commission's adoption of Resolution 275, promoting the protection of sexual orientation and gender identity people from discrimination and violence. Now we come to the success of the African Charter. The African Charter explicitly provided opportunity for the people to debate human rights problems facing the region, as well as providing a space for contributing solutions for addressing Africa's human rights problems. The Commission accelerated the protection of human rights in the continent by developing normative standards, soft law, guidelines, and research studies. It also built up a wealth of African jurisprudence in response to the communication submitted to it. The Commission further ensured protection of vulnerable groups, including women, refugees, children, indigenous populations, sexual and gender minorities, people living with HIV/AIDS, persons with albinism, persons with disabilities, and older persons. It also adopted resolutions advocating for democracy, freedom of expression, information, association, assembly, peace, and natural resources. Challenges that the Commission faces, faced by the African Charter. The Commission is established to promote and protect human rights impartially, independently, without fear and favor in the region. However, the Commission's mandate was interfered by the AU Executive Council when it instructed the Commission in 2015 to withdraw the observer status of a CSO promoting women and sexual minority rights. Although the Commission reiterated its oversight independence over African Charter and still has reference to Resolution 275, the observer status of a CSO working on LGBTI rights remains withdrawn. The Executive Council even went further by requiring an amendment of criteria for granting and maintaining observer status for NGOs working on human rights and people's rights in Africa. In response to this, the Commission adopted Resolution 361 in 2016. The lack of implementation by states of the decisions of the court and the recommendations of the Commission remains a challenge. Concluding observations passed by the Commission recommending reforms are often not implemented. Direct access to the African Court also remains a challenge. The Commission has also not been made full use of referring cases to the African Court. In my conclusion, Prof, let me say that by noting that states parties to the Charter have to submit periodic reports every 2 years highlighting progress made legislatively and administratively to advance human rights at the national level. Although South Africa had submitted 2 previous reports, it now has an outstanding periodic report. The concluding observations the Commission issued in 2016 have largely not been implemented, including that recommendation that South Africa should make an Article 34.6 declaration accepting direct access to the court. We congratulate Advocate Justice Tumisa Buhle Ntsebesa, who is the Senior Counsel in South Africa, newly appointed judge of the African Court, and we are looking forward to working with you on these significant human rights instruments to strengthen work of these regional human rights bodies in South Africa and across the continent. I thank you very much for this opportunity.
Thank you so much, Colette, for those contextualizing and thank you words. We are guided by those remarks. Now we get to the real meat of today's event. We are looking at the 5 extraordinary South Africans that are our guests of honor who have each contributed to the work of the African human rights system. I should pause to say that there may be others, and there are others, in addition to these 5, whose involvement perhaps is still a work in progress. I'm thinking here of the current acting Executive Secretary of the African Commission on Human and People's Rights, Ms. Lindiwe Khumalo, who clearly is also a South African and is in the process of leaving her footprints also on the African human rights landscape. Permit me, please, to say a few words just about the Commission and the Centre's involvement with the Commission. We've been privileged as a Centre for Human Rights over the years as enjoying observer status with the Commission to work in various ways with the African Commission. One of these ways had been to prepare a publication, a concise, informative, yet accessible publication or booklet on the African human rights system. And we thought it opportune today to launch a revised and updated version of that publication, a guide to the African human rights system in commemoration of the 40 years of the African Charter today. So we hope that this will be useful to you. I think the details of that will also be displayed in the chat. So that is the guide on the African human rights system that hopefully will be useful to each of us. But let me turn to the first of our commissioners, that is Commissioner Barney Pityana. Where to start to introduce Professor Pityana? I think he's a Pan-Africanist in word and deed. He's been the chairperson of the South African Human Rights Commission. He has been the first black person to be appointed as the Vice Chancellor and Principal of the University of South Africa, serving from 2001 to 2010. But as far as the Commission is concerned, he served there from 2007 to 2003 for one term. Personally, I am in admiration of his work, particularly around indigenous people's rights. He was one of the people first in the Commission to recognize the plight, the importance of securing also the rights of indigenous peoples in Africa and contextualizing and conceptualizing the concept. So we have a short video that we will play to further introduce Professor Pityana. And Professor Pityana, please, at the end of this video, we ask you to please take the virtual floor for your remarks.
At that time, the state law advisors had been advising government against ratifying the protocol of the African Court of Human and People's Rights. It seemed to us to be a very strange position for the state law advisors to take. And the predominant thing, and this is there even today, that was a concern for them, was that we have a constitutional court, and the manner in which the constitutional court works and operates should be sufficient to obviate any problems and challenges that citizens would have. Good morning, friends, and thank you very much for the invitation to participate in this event to mark 40 years of the adoption of the African Charter on Human and People's Rights. A particular gratitude to Professor Frans Viljoen and the Center for Human Rights at the University of Pretoria, a pioneer in human rights work and research at universities in South Africa. I also wish to thank the South African Human Rights Commission, Advocate Bongani Majola and Advocate Sidiso Tipanyane, both friends and colleagues who have participated in this and indeed have advanced the work of human rights in South Africa and the partnership with the African Commission on Human and People's Rights. To my good friend, Colette Litlonyana, the CEO of HURISA, Human Rights in Africa, for the invitation and for really working together to put this thing together. To all of you and others who participated, I am eternally grateful. Lovely to see my other colleagues and good friends participating in this. Advocate Pansy Tlakula, together we were in the first tranche of human rights commissioners in 1995. And I'm also delighted to have my Chancellor, Judge Bernard Ngoepe, who for me will always be Chancellor because he was our Chancellor at UNISA for very many years, as well as my other good friend and colleague, Dumisa Nsebeza, who is now a judge in the African Court on Human and People's Rights. Delighted to be here. I have been advised that I have exactly no more than 10 minutes to do this talk, and typical of Frans Viljoen's style, and he's set out exactly what I'm supposed to be saying and how much time it must be done, and I shall duly oblige. I've got really basically 3 points to make, like a good preacher. The first one is to say briefly it was a great honor for me to be invited to serve in the African Commission. It was a huge privilege to be asked to represent South Africa by then Minister of Justice, Dala Omar. And getting to Banjul for my first session was just a tingling sensation and excitement that I felt to be in the presence of some of these great African human rights lawyers who really wanted to make a difference in the continent at a very, very difficult time. And I can think of the chairperson who was the Chief Justice of Senegal at the time. And he was a really committed person, senior person, held with much respect. And over the years, Dr. Badawi from Egypt, and particularly wonderful Professor Ngoepe from Gabon, and Professor Dankwa. So the quality of the people who were in the commission was truly, truly, truly amazing. And it was very good to be in their midst. It felt extremely good. The second thing I recall about that is that there was a great deal of expectation from civil society organizations, from human rights activists, at a particularly difficult time. People really did expect the institution established to advance the Charter to really do its work. And so, but there was a very tense relationship between the human rights organizations and NGOs and the Commission itself. In part, it was a sense that the Commission wasn't really doing enough to push its role in protecting human rights in Africa. But at the same time, there was a sense that the Commission, in the interpretation of the Charter, in its decisions, could be much more activist in orientation than the Commission was inclined to do. And so the advent or the emergence of a South Africa for the first time in the Commission, it's true what Frans is saying, gave a lot of hope, and Colette gave a lot of hope to many NGO activists, a lot of expectation, partly because they'd been quite exhausted and frustrated by not so much that the Commission was not doing its work, but it was not going far enough than it should actually do. But to be there with NGOs and in Africa was also a great event for me, and really appreciated the expectation and the trust at times that people had in the Commission. In the work of the Commission itself, while I was there, let me just say three more key things. The first thing, we battled a great deal to try to understand what indeed was African beyond of the African states. How to dynamize the idea of being an African commission, an African charter for human and people's rights. And of course, it was always known in scholarly circles. And in many scholarly circles, it was said that the African Charter was actually very weak. And it was deliberately so, deliberately weakened by the manner in which it was constructed. The idea of the sections of the Charter that were about individual rights, no individual could do that. Then the second one was about people's rights. And then it had a section on duties. And many people thought there was too much emphasis at times in the idea of duties and very, very limited advancement of the idea of rights. And there was also a great deal of trying to advance the rights of the peoples, of the communities, as an expression of what the Charter actually intended, rather than was the protection of individual rights. So the second thing about it, it was felt that the Charter was weak because it almost everywhere it seemed to allow derogations, and it was felt that the Commission itself, in its interpretation, was hampered by its regard for derogations. The other thing that made the Commission, in the eyes of many, rather weak was the fact that for too much, the states didn't seem to be paying attention or honoring their rights and obligations towards the Charter. And I must say that at the time that I was there, I could see the increasing extent to which states were paying attention to the African Commission and its work. And increasingly, states were coming to defend their periodic reports, or present and defend their periodic reports. Increasingly, states were sending state delegates to the sessions of the Commission. Increasingly, states were allowing commissions and commissioners to actually visit their states, whereas before it's something that had become very, very difficult. Then I want to say two things: the achievements of the Commission during the time I was there. I'll probably mention one or two. The first one, I think we managed to move the Commission towards a much more progressive and developmental approach in the interpretation of the Charter than had been the case before. Made it possible to kind of move a little bit away from its defensive approach to states and to issues like collective rights, for example, and this defensiveness of the Commission. I think we managed on several reports to get the Commission to break through that and to accept that the Commission had to interpret the Charter in as progressive and developmental a manner as possible. I think the second thing that I would say was an achievement during the time I was there is to clarify the observer status of NGOs and to establish the idea of dialogue and interaction between the Commission and the NGO community that increasingly was beginning to be having a lot more confidence in the Commission. And the third achievement, I think, is to say that actually the reports of the Commission became, I could see that they were becoming with a lot of content and quality in the reports, was observable and easy to see. A lot of attention was being paid to detail, and the jurisprudence of the Commission was, I think, a lot more usable. Now, I became a member a bare 10 years or so since the Commission was established. The earlier years had been a lot like years of establishing the Commission, and the earlier days of trying to find out a lot of work was done. So effectively, I would say when I got there, the Commission had been really smooth and running, as it were, something like 6 years. So my coming there, I have to say, was in the early stages of the operationalization of the Charter and of the Commission. Then I think on this, for me, was a very, very difficult thing, because there were a couple of decisions that were made which were rejecting the idea of self-determination in Africa. In other words, indigenous peoples and indigenous communities could not possibly, because the idea was that everybody in Africa was indigenous to Africa. And therefore the commission was very, very hostile to the idea that there were indigenous peoples in Africa. So we had to work on this together with IFGIA to really open up the commission's legal interpretation to understand how it was possible for Africans within Africa to be indigenous and what that actually meant. And that led, I think, if I recall, to a statement or declaration that was passed towards the end of my time at the commission. So the work of and that work actually, and what we did spilled over to the United Nations, and that led to the UN Declaration on Indigenous Communities as well. But more importantly for me was that there was an acknowledgement by IFGIA of the pioneering work that the African Commission managed to do. Finally, I hope I'm still within your time. Finally, let me just say that being a South African was a great privilege in the Commission. The work I was doing in South Africa, fortunately, I was also chair of the South African Human Rights Commission. I had a lot of support from my colleagues in the Commission. I had a lot of support from the Department of Justice and the Minister for the work of the Commission. And I had a lot of support from the Department of Foreign Affairs, as it was at the time. But more importantly, especially towards the end, at a very, very difficult time on Zimbabwe, Minister Nkosazana Dlamini Zuma was the minister at the time, and she was having to defend the reports that we did at the Council of Ministers, I think it's called, and it was possible to actually go and present the report to her and make sure that she understands what we are doing. And I am very honored that she really, at a very difficult time, stood up for the Commission and the reports that we did. And the report that I did, I generally did on Zimbabwe, was apparently a very, very difficult one that government of Zimbabwe wouldn't accept. So I think that the relationship we had with the government was a very good one. And also, we had very, very good meetings during the summit of heads of state and government. Whenever we could go there, President Mbeki always gave us audience in preparation for the presentation of the report of the African Commission in the Assembly, so that with a briefing and the needs of the Commission, he was always sympathetic in listening to how we can strengthen the Commission in Africa. And yet, there were things that needed to be done that I think were unfinished business in South Africa about the work of the Commission. I mean, I want to end there, Professor Viljoen, to say that it was a great privilege for me to be a member of the Commission. I think I learned a lot and gave a lot of hope to what the Commission could achieve. Thank you.
Thank you very much, Professor Pityana, Barney. It's wonderful to have an insider's perspective, and I think your perspective really made history come alive in our eyes and ears. So thank you so much for sharing those thoughts, and also pointing to the role of government. Obviously, the Department of Justice and the Department of International Relations and Cooperation are quite important role players in maintaining good relations with the African human rights system. We have their support. Regrettably, none of the relevant ministers and deputy ministers could attend today, but just to acknowledge, as you said, their very important role in the broader sense of South Africa and its role within the African human rights system. We turn to another South African of great distinction, a second person who served on the commission, and that is Advocate Pansy Tlakula. I'd say she is a South African of great distinction for a number of reasons. First of all, as Barney pointed out, she was one of the trailblazing first commissioners on the South African Human Rights Commission. She served as the National Director for the Black Lawyers Association. And as I think many of us know, she also was the Chief Electoral Officer and later the Chairperson of the South African Electoral Commission. She also now has become the Information Regulator of South Africa, and she serves on the United Nations Committee on the Elimination of Racial Discrimination. But today, the most pertinent point is that she served as a member of the African Commission for the years 2011 to 2017, and for the last 2 years, she served as the chairperson of that commission. Those were turbulent years, years just following the Executive Council's decision that the African Commission should reverse its granting of observer status to South African NGO, the Coalition of African Lesbians. So the clip, Pansy, that we'll see will remind you of that context, and we ask you, once we've listened and seen the clip, to please again take the virtual floor. Thank you.
Importé. C'est un virus nouveau qui date depuis quelques années pour diviser les Africains, pour les détourner des vrais problèmes qui s'opposent à eux.
Commissioner Pansy stood up and said that this language is problematic, and I'm calling you, Vice Chair, to order.
To the Deputy Chair of this commission, I heard him use the word virus. So the word use of the word these are words that were used, and we know that use words like this, like cockroach and so on, were used in Rwanda and led to genocide.
Sure. Thank you very much and good morning. I hope you can see me and you can hear me. It's a great honor to be here this morning. Thank you very much to the Center for Human Rights, HURISA, and the South African Human Rights Commission for putting this commemorative day together. Let me greet the esteemed panelists who are here: Judge Ngoepe, the former President of the African Court, Professor Pityana, who served also on the African Commission on Human and People's Rights, Advocate Majola, I see you have joined the meeting, Ms. Colette Letlojane. Let me also take this opportunity to congratulate Advocate Dumisa Ntsebeza for his successful election to the African Court on Human and People's Rights. This is a milestone for our country. I was a member of the African Commission, actually, Professor Viljoen, from 2005 to 2017. For 12 years, I served 2 6-year terms, and towards the end of my stay at the commission, it felt that I was kind of becoming a commissioner for life. I was ready to leave. But it was, like Barney said, it was a great honor and privilege for me to be afforded the opportunity to serve on the commission and also to be elected as as its chairperson for the last 2 years of my tenure at the Commission. I spend a whole lot of time, as Colette has indicated, as the Special Rapporteur on Freedom of Expression and Access to Information in Africa. A very difficult mandate at that time, and a mandate that remains difficult at this point in time, taking into consideration the issues of media freedom on our continent and elsewhere in the world. And I found it to be a very confrontational mandate, because there was always confrontation between journalists on one hand, media practitioners, and governments, and media practitioners who continued to experience arbitrary arrest, murder, and so on, with impunity in their country. So I took over the mandate at that time, and I must say that the situation has not improved a lot since then. We have made very little progress in that area. But one of the most successful projects that we undertook was to get the Commission to adopt a model law on access to information in Africa, after realizing that very few countries on the African continent had adopted access to information laws. And we found that, as we know, the right of access to information is a cross-cutting right that enables the enjoyment of other rights. So we thought it was important for countries on the continent to adopt access to information laws. So we began then by drafting access to model law on access to information, which countries used to adopt their own national access to information laws. The project was very successful, because when we started it, only 5 countries on the continent had access to information laws. And by the time I left, more than 26 countries had actually adopted access to information laws using the model law. But we had to crisscross the whole continent across the 5 regions, having consultative meetings on the draft draft model law, and thereafter we also assisted with the implementation of the law. I think that project was quite successful, because I'm looking back, and now, as Franz introduced me, I'm a member of the Information Regulator, and tomorrow the Information Regulator will take over the function of regulating PAIA, the Promotion of Access to Information Law, from the South African Human Rights Commission. And the work that we did on access to information in Africa, I think, has come in handy, because we were able to establish the African Network of Information Commissioners. And these are commissioners that are responsible for access to information on the African continent. And I've had the privilege of serving as the interim chairperson of that network. I think another important project that we did in my capacity as the Special Rapporteur on Freedom of Expression was to spearhead the drafting of the guidance note on access to information and elections. This is, in my view, as far as I know, the first standard-setting document globally on access to information on elections, which guides all stakeholders involved in the electoral process on what information they should proactively disclose to the public in order to enhance the transparency, the freeness, and the fairness of the electoral process. In 2012, I think it was, my mandate also sponsored a resolution that was adopted by the Commission, which among others requested the African Union to declare the 28th of September as the Freedom of Information Day. And this resolution contributed towards the declaration of the 28th of September as the International Day for Universal Access to Information by UNESCO in 2015, and subsequently by the UN General Assembly in 2019. And I think as the chairperson of the commission, one of the most important or difficult functions that I had to perform was to present the activity report of the commission at the summits of heads of state and government, and our reports were submitted to the PRC, Permanent Representative Council. And I found that one of the most difficult functions that I had to execute. Of course, the PRC engaged robustly with the report, the activity report of the commission, but at the same time wanted us or the commission to change its activity report. And I found that I had to really defend the activity report of the commission, and stated categorically that the PRC had every right to criticize the activity report, but that they had no right whatsoever to change the contents of the activity report, because we felt that doing so went to the heart of the independence of the commission as a treaty body. And I must say that for the 2 years that I was the chairperson of the commission, I resisted that, and I really put up a good fight. And during my tenure, the activity report of the commission was never changed. And I think what this charter meant to South Africans, I must say that I look back under the leadership of Professor Pityana in 2009, I can't even remember when it was, but just before the World Conference on Racism, which was held in Durban, I think it was 2001, under the leadership of Professor Pityana, who was a member of the commission then, and the late Ambassador Resak Bara, who was the chairperson of the commission. We organized the African preparatory meeting for the World Conference Against Racism. That meeting was held in Dakar, Senegal. I think this was quite important because without the leadership of Professor Pityana, I don't think Africa would have had a meeting to prepare for the World Conference Against Racism. And I think for South Africa as well, another important part that was played by the civil society in South Africa was to lobby the commission to address violations of human rights which were perpetuated against persons on the basis of their real or imputed sexual orientation or gender identity on the African continent. And we know that at that time and now, lesbians were murdered with impunity. That continues. And I think because of the work that civil society did, the South African civil society, the commission was able to adopt a resolution 275 on I think the resolution is called Violence and Other Human Rights Violations. It's the resolution on addressing violence and other human rights violations perpetuated against persons on the basis of their real or imputed sexual orientation or gender identity. I think this was it's a very important resolution that the commission adopted in 2014. And as I am about to finish, I see that my time is over. What the future of the charter in South Africa? I think I was pleased actually in 2019 to read the judgment of the Constitutional Court in the case of New Nation Movement versus the President of South Africa. And this case was brought by the New Nations Movement on the challenging the Electoral Act to the extent that it did not allow independent candidates to contest national and provincial elections. And I think we are all aware of that case. But when I read that judgment, I was quite pleased that our Constitutional Court quoted with approval a decision that was made by the African Court on Human and People's Rights in the case of Tanganyika Law Society versus the United Republic of Tanzania on the interpretation of Article 10 of the African Charter. I think our courts, should continue or in fact increase the reference to the jurisprudence of the African Court on Human and People's Rights and the jurisprudence that came out of the African Commission on Human and People's Rights. So I think this was quite refreshing to read that judgment and how the court referred to the jurisprudence of the African Court on Human and People's Rights. Finally, I think it will be good for our government also to commemorate days such as this. I mean, the Charter is 40 years, or 40 years on Sunday, and there is absolute silence, deafening silence in our country as far as the celebration of this important day is concerned. And maybe one of the recommendations that should come out of this is that maybe Parliament in future should consider commemorating this day, because that will then enhance the visibility and the understanding of the Charter in South Africa. Thank you very much for giving me this opportunity.
Thank you very much, Advocate Tlakula. Again, sharing your insider's perspective, but also reminding us that sometimes it is necessary to fight the good fight. And certainly, yes, 2 terms, 2005 and to the end of 12 years, you've really contributed immensely. And thank you for pointing out to these concrete instances of how the African Charter and the Commission's work have been instrumental in really affecting people's actual lives. Let us then now turn to the African Court on Human and People's Rights. As I think Colette earlier indicated, the court started functioning in 2006. So 2021 also marks a 15 years milestone of the functioning, the operationalization of the African Court. So we are very pleased also to invite another exceptional jurist, a jurist of great standing in South Africa, to address us briefly about his insights. That is Judge Ngoepe, Bernard Ngoepe. He is presently heading the Office of the Tax Ombud in South Africa, but previously, as I think most South Africans would know, he served for many years as judge of the High Court of South Africa, 18 years in total. 14 years of those he served as judge president of the North and South Gauteng High Courts. He also acted for periods of time with the South African Constitutional Court and the Supreme Court of Appeal. His term with the African Court on Human and People's Rights was from 2006 until 2014. He was elected initially by the drawing of lots for a 2-year term, and then his term was extended by another 6. Again, an illustration of a trailblazer. Judge Ngoepe then was part of the first group of African Court judges. In the clip that follows, I think the emphasis is placed also on his contribution to the jurisprudence of this court through his separate or minority opinions. Thank you very much for honoring us with your presence, Judge Ngoepe. After listening to the clip, we invite you to take the floor and share your remarks with us.
What I regard as the high point of the court's work thus far, the minority judgments that Judge Ngoepe authored and alluded to, and out of respect and honor, the place of minority judgments should be enhanced. Some courts do not have the right to write minority judgments. Some courts do not like doing so. Some courts like to speak in the voice of the court only. Right from the start, and from those first judgments,
people always think that you come to court on contentious matters, but you can also approach this court for an advice, an advisory opinion, because a country may, for example, set up its own constitution, and then before putting it into operation, they can approach our court to find out whether the provisions of their constitution relating to issues of human rights are compatible with the African Union's Charter on Human Rights. And then we'll advise them. And if they take our advice, if we feel that their constitution is going to be in conflict with the Charter, then they would redraft it in such a way that it would not be in conflict.
Thank you for the invite. That clip must be quite old because I still had a lot of hair then. I must apologize for joining you late because I didn't realize until it was late that you have moved from that particular platform to this one. Yes, thank you for this invite, and I'm pleased to see these distinguished members of the panel whom I've known for a very long time. Professor Pityana has just said that he would always refer to me as the Chancellor. He also knows that once he gets a call and somebody on the other end says, Mr. Principal, then he knows it's from me, because up to now I still call him Principal. Ms. Tlakula, you made mention of my participation in Angola with regard to the recognition or rights of the LGBT. I don't know, it's such a difficult acronym. I always never get it right. You can't expect a retired mind to remember all the time accurately such a complicated acronym, LGBT, whatever. And I remember being asked to adjudicate between, on the one hand, people like that and members of the Ugandan parliament. There was a huge dispute between them. And in the end, the results were encouraging. We must wish Dumisa very well in his new appointment. And before I go further, I'm sorry, I've got to say that we are really, really in trouble in this country, perhaps not only in this country, but this pandemic is very serious. In the past 12 days or so, I lost two of my former judges, one of them my former deputy, and only on Sunday, a third judge, lost his wife within a few days of the onset of the pandemic on her. And this morning I got a message that one of the distinguished senior counsel, Mr. Price, has died of COVID, and that two of them, of the distinguished senior counsel, Paquin and somebody else, are fighting for their lives right now in the intensive care unit. So this thing is real. We're really in trouble. We need to look after ourselves. But thanks for the invite. As far as the African Court is concerned, let me tell you that one of the things that impressed me, which was a significant moment on the continent, was the establishment of the court. Let's leave aside its efficacy. Let's leave aside on whether it has made the necessary impact or not. But to me, as you have heard, the Commission, the African Commission, would time and again submit reports, and these reports would not always be implemented and respected. People even loathe the reports of the African Commission. Now, it was the same people who mercifully agreed to have a court which would make binding pronouncements. And to me, that was a huge paradigm shift from people who were reluctant to even implement the recommendations of Commission to getting to a point where they would accept binding decisions of a court of law. That was a huge paradigm shift. And it was a big moment for me. And I do recall the day on which we took the oath of office. And I felt to myself, this is a very important step. It may well be that the court is not as effective or as it is, but the important thing is that it does exist. And to a certain extent, it has a deterrent effect on the thinking and on the conduct of would-be offenders or perpetrators of human rights. Now, it has been mentioned that I was one of the founding judges of that court. And perhaps this also in a way speaks to the connection between South African Constitution and the African Charter on Human and People's Rights. I was one of those people who, not because of arrogance, of sense of self-importance, but one of those South African judges who felt that such a court should not be started as far as possible without input or participation by a South African judge. Not because we knew better than everyone else, but it was because of the deep hurt, the injury to our dignity and the injury to our human rights in this country. We felt that we needed to go there and help shape up the jurisprudence of that court, lay down the principles for that court with this painful history of ours still in mind, to make sure that nothing went wrong with that court. I don't know whether we succeeded, but that was the idea behind that. And therefore, we tried to breathe into the working of this court that kind of spirit that would maintain and protect vigorously the human rights. Now, the other thing with the court is that, yes, as I've said, we did make some pronouncement, we did make some orders, and we can't talk about positive things only, we must talk about the few negatives within this short period of time. The difficulty with that court, perhaps its weakness, was it came with regard to the issue of implementation of the orders or the judgments made by the court. There was no political will on the part of the heads of state to make sure that the orders of the court were properly implemented. Yes, it was a momentous occasion when we sat, for example, and made an order against the then new Libya, because Muammar Gaddafi's son was detained in Tunisia, and later on was, before we could pronounce ourselves, he was moved back to Libya. But what we managed to do was to issue an order, ordering the Libyan government to make sure that he got medical treatment, he got visits from the close family, and so forth and so on. They did not quite honor the orders as we had ordered. And we then compiled a report and submitted it to the AU, to the summit. And at that time, I was the vice president of that court. In our report, we indicated very clearly in no uncertain language that Libya had to be taken to task. They defaulted against the order of the court. Advocate Tlakula just mentioned something about people pressing for their resolutions to be watered down. That's exactly what we experienced. The report, we were forced to water down the report so much that in the end, it really did not mean much. But that is the weakness of that court. And then, of course, the other issue that we must talk about with regards to that is how what that charter meant to South Africans and that court. Well, as I've said, there's a connection between the court, our own constitution, and of course the charter that established that court. But our thinking was always that with the passage of time, the jurisprudence of the African court will filter down to national levels. And to that end, when I was still there, we planned that from time to time, we would bring together chief justices throughout the continent. They should come to the court. We would have a workshop and engage on the recent developments and jurisprudence of that court. In fact, what we did was to persuade the AU to recognize as part of the activities, official activities of the court, a program in terms of which chief justices throughout the continent would come to the court for a participation and jurisprudential discussion, so that that prudence will filter down to national levels. We hope by so doing, we would be able to get that kind of jurisprudence to filter down to the national levels. But The problem with South Africa has always been one. I think we suffered too much under isolation. This court, the African court, has never really been popular in this country. It has never been that much known. And in fact, when we came to, there was a time when I queried that court and I said, I keep on interviewing candidates for appointment positions in this court. I've never seen a South African. I've never seen a South African shortlisted here. And the registrar looked at me with a broad smile and said, Judge, if you can just help us convince South Africans to apply to positions to this court, would be gladly shortlist them if they qualify. I was embarrassed, but not so much, because how many people do even know in South Africa that I once served in that court? How many of them do know that I was even vice president of that court? Not many. I think we need, as South Africans, in order to get the benefit of this continental jurisprudence and the golden thread of this wonderful charter with all its weaknesses, though, to be woven into our own jurisprudence, we need to break out of this isolation mode and participate in the projects on the continent, and in this particular case, to engage the court to be involved with its activities. I suspect my time might be coming to an end, but let me talk to the issue which Professor Viljoen asked me to touch on, that, and that is South Africa possibly making the declaration that individual people could take cases to the court, the 34-6 so-called declaration. Yes, I'm not surprised that there is no representation for the Department of Justice or Department of Foreign Affairs, whatever you call it now, because they've not been very enthusiastic about this particular court. I personally took the trouble to arrange, as my other colleagues did in respect of their countries, a delegation of the court, the entire court, to visit this country some years ago to meet the head of state. And I must say, we had been visiting heads of state throughout the continent, trying to convince their countries to make the declaration. I took the trouble to make that arrangement for the court to come here, which it did. I invited Department of Foreign Affairs at the time. They did not even respond. Minister of Justice did not respond. None of them even made the trouble to come and meet the court's delegation here. What happened was the delegation was at least received by Mr. Sisulu, then as the Speaker of Parliament, and the lady who was, my goodness, the lady who was, is present Speaker anyway, my dear sister. But the government, official governments, never bothered to meet that delegation. So don't hold your breath. The South African government is not about and will not be about to make a declaration in terms of Section 34.6. You'll have to work hard, we'll have to work hard, all of us, to do that. I think I should stop there, especially because I think I've gone beyond my time. And thank you for the invitation. There are a few more interesting things we have discussed, but maybe they could come up during the Q&A session. Thank you.
Thank you very much, Justice Ngoepe. I think what you have actually narrated in your opening remarks, it's just reminiscent of a repetition of what is currently happening in the using the mechanism or understanding or expecting these institutions to be respected, to fulfill their functions without fear and independently. And the government have got duties to popularize these institutions and the mechanisms. And it's surprising that you have been advocating for South Africa to make this declaration, acceptable or be signed so that we can have access to the African court. And right now we are isolating ourselves because all decisions of our court have to be respected if they are made by the African court. We can't move out of the country. And there are many challenges regarding people that have been served, that have been handed out with decisions that they feel that are not acceptable. I think we need to look at new ways, innovative ways of making the African Charter, the African Commission, and the African Court more, effective and holding governments accountable to their commitment. I thank you very much for that. I'll now introduce one of the champions that I will address as very vital in the work of the civil society. South Africa made us proud by nominating, seconding Mrs. Caron Kgomo. Mrs. Caron Kgomo, at that time, when we saw her arriving at the commission, we thought she was one of the state delegates attending sessions of the commission. That was in 2007, and she has actually arrived to provide technical support to the special rapporteur on the rights of women in Africa, and also to increase the capacity of the African Commission. And we have seen the invaluable work, precedent that she has set up in facilitating communications and arrangement for civil society to engage with the Commission, state parties, and also national human rights institutions. Ms. Kgomo, she is from Department of International Relations. She's in the Gender and Diversity program. And then she is now back, she's been back in South Africa since 2011. And I would like her just to give us her own experience and in sharing how the experience she had at serving at the African Commission, engaging with civil society, engaging with national human rights institutions, as well as state parties. What lessons can we learn from there? And then what it is that you are recommending as a way forward. Thank you, Ms. Kgomo.
Thank you very much. I hope you can all hear me. And it's still good morning. I am going to stand on the already established protocol in greeting everybody who has spoken. And Program Director, Prof. Franz Viljoen, and the co-convener, Mekollet Lutlojani. I salute everybody on the already existing protocol. I'm also taking the opportunity to really salute the fallen and unsung heroines and heroes who succumbed to COVID-19. Judge Ngoepe indicated that this is really a serious pandemic. I'm very grateful that I'm able to address this meeting today, as today is my 9th day being in isolation, having tested positive. I have overcome COVID-19, and I really take this very serious and with humility. Excellencies, distinguished ladies and gentlemen, It is a great honor for me to address you as we mark the 40 years anniversary of the African Charter on Human and People's Rights. The Charter, which was adopted by the Organization of African Unity on the 27th June 1981. We simultaneously also mark 35 years anniversary of the African Commission on Human and People's Rights, which is an organ of the AU that is mandated and tasked to be the custodian of this instrument. The Charter was established to promote and protect human and collective people's rights throughout the continent. The celebration of this landmark instrument for human rights takes place in the significant month of June, when in South Africa we are celebrating Youth Month under the theme Youth Power, Growing South Africa Together in the period of COVID-19. All activities during this month were recognizing the present and the future role of young people shaping the socio-economic landscape of the country, reminding us of the youth significant to human rights observance, and recognizing also that Africa's outlook is very youthful and we need to harness the demographic dividends of this generation. The commemoration of this 40 years of the African Charter on Human and People's Rights is also taking place during the Pride Month, when the nation reflects on the rights of the LGBTQI community. While this is meant to be a time of celebration, it is an important moment to consider the specific needs of the community and how to address them to build a better future. South Africa's legal system led the way for marriage equality and legal protection against discrimination. We are the first country in the world to protect against discrimination based on sexual orientation and the fight for legalize same-sex marriages. A lot more needs to be done considering the violation and discrimination experienced by the LGBTQI community in our society. We also commemorate 40 years of the African Charter, 6 years since the 25th April 2015, when the African Commission on Human and People's Rights granted observer status to a coalition of African lesbians. A lot of the speakers have alluded to that. It was mainly South African organizations and the role that advocate Pansy Tlakula played that led to this push and acceptance. We saw increased collaboration among international civil society organizations and continental civil society organizations engaging in social movement in support of cause, in particular extending that to the LGBTQI community and their rights. As we celebrate the African Charter, we need also to be mindful of the fact that the protection of women under Article 18.3 was deemed insufficient. Women's rights activists found that the Charter does not address issues considered central in the African context. These were issues such as female genital mutilation, women's inheritance and reproductive rights, forced marriages, and combating HIV and AIDS. Therefore, there was a need for additional instrument to specifically address the rights of African women who made up the majority of the African population. Consequently, civil society organizations and non-governmental organization sectors initiated work advocating and calling for the protocol on the rights of women to be established. The process was accelerated by the adoption of a resolution in 1999, which appointed the Special Rapporteur on the Rights of Women in Africa. The Protocol on the Rights of Women in Africa was eventually adopted by the Conference of Heads of State and Government of the African Union during the summit held in Maputo, Mozambique in 2003. This move further gave strength to the human rights system in Africa. The preamble of the protocol reflects that general consent that led to its establishment. it states and reflects on that inadequacy in the African Charter. And it says that despite the ratification of the African Charter on Human and People's Rights and other international legal instruments by the majority of state parties and their solemn commitment to eliminate all forms of discrimination and harmful practices, women in Africa continue to be victims of discrimination and harmful practices. Because this was the reason why the protocol had to be established, to promote these rights and address specific African women's issues. To date, we see 42 African countries that have ratified and acceded to the protocol. The Special Rapporteur on the Rights of Women was given the mandate to promote the protocol and to serve as a focal point for the promotion and protection of the rights of women in Africa. The SAHRC was further to ensure the general harmonization of national legislation to the rights guaranteed in the protocol. She was to undertake promotional and fact-finding missions in African countries, member states of the African Union, in order to disseminate the human rights instrument for the African Union and to investigate on the situation of women's rights in countries we visited. The protocol was the first regional human rights instrument in Africa to specifically address women's rights, including explicit protection of women's sexual reproductive rights. Another first in the protocol's call was the call for prohibition of harmful practices such as female circumcision or female genital mutilation, which have ravaged the lives of countless young women in Africa. It became the first instrument that adequately closed the gap that was identified as a missing element in the African Charter, thus playing a significant complementary role to the Charter. Now, during my time when I was seconded to the African Commission on Human and People's Rights, serving there, South Africa was continuing to champion the promotion of the African Charter and the Maputo Protocol through its foreign policy implementation. The government of South Africa is always in the forefront supporting the African Union and its organs to ensure that they deliver on their mandate. The significant contribution to the special mechanism on the rights of women in Africa was pursuant to South Africa's foreign policy directive, which is geared towards creating a better South Africa that contributes to a better and safer Africa within the context of a better world. In 2004, the government of South Africa collaborated with the Swiss government in strengthening the mandate of the Special Rapporteur on the Rights of Women in Africa. This led to both governments deploying technical experts, respectively, for a period of 4 years. And I was chosen to be that expert to represent South Africa and strengthen the special mechanism on the rights of women in Africa. Following this collaboration, the former Commissioner Angela Melo, who was the Special Rapporteur at the time, was informed of the decision, which she gladly welcomed. The support was both human and financial, as each government offered to cover the financial cost of the secondee. Subsequent to this, South Africa identified me and seconded me to the Secretariat of the Commission in 2007 to 2011. It was at that time when I met both this program director, Professor Viljoen and Mekolete Litojana, who were champions of civil society. I remember the first time when I met them, and they were inquiring about their participation in engaging in the running of the commission. The deployment of this resource, which is myself, was actually helpful to the women's rights special mechanism to achieve and was able to achieve significant impact. Through the support of the CSO, academia, in particular the Center for Human Rights and the Human Rights Institute of Southern Africa, the African Center for Democracy and Human Rights, a number of advocacy tools were developed. Those toolkits were aimed at familiarizing the broader stakeholders which is members of the civil society and non-governmental organization in the main, with the mandate and the activities of the special mechanism, in particular the Special Rapporteur on the Rights of Women. It was also through South Africa's support to the special mechanism on the rights of women that we were able to develop the guidelines, the guidelines for state reporting under the protocol to the African Charter on Human and People's Rights on the rights of women in Africa. I remember when we met with Professor Viljoen, and we had a conversation to say, we have been given this opportunity to really make an impact in the Office of the Special Rapporteur on the Rights of Women in Africa. And we need to leave a lasting legacy. And Professor Viljoen indicated that we have the expertise, which is the young people who are students in the Center for Human Rights, legal students, and therefore we can bring them together with civil society and experts and draft the guidelines that will assist member states to prepare extensive reports that speak to the rights of women and the implementation of the protocol. And indeed, we were able to develop a booklet which was adopted by the Commission, which now serves as a guide for state parties to report under the protocol. The center also sponsored interns who were placed at the SAHRC not only to learn, but provided added technical and expert context to the work of the Commission. One cannot also underplay the pressure the Commission experienced, which necessitated the development of working method for effective participation of civil society in the sessions of the Commission. And I think Colette alluded to that. There was a time when in the Commission, we did not have a proper working method where civil society will engage freely in the deliberations of the sessions of the Commission. This led to a system being established that afforded civil society ample time to present their issues before the Commission session, while at the same time also affording state party representatives their right to reply. Currently, there is a body of knowledge of existing statements that were made in the archives of the Commission, which can be accessed at any time. Civil society organizations are able to plan their participation professionally, knowing very well that there's a mechanism that exists for them to engage in the deliberations of the Commission. It was through the active participation and involvement of South African civil society and those that were deployed to serve as commissioners in the Commission that ensured that South Africa not only adopts domesticate the Charter, but highlighted that its overall implementation is very critical. The work of the African Commission, in particular, the African Charter, the Maputo Protocol, and other instruments and special mechanisms remain relevant. Socioeconomic imbalances that are exacerbated by COVID-19 pandemic continue to trample on the human rights of ordinary people. We have to support equal access to the vaccine and demand it as a human right across all sectors. And that is the role that civil society play and continue to play from time that I have learned to work with the Commission. The growing gender-based violence and femicide, which now saw the development of national action plans in many countries and national strategies, must be aligned in practice to the continental prescripts, while civil society ensures they play a watchdog role, compelling member states to adhere and implement those national action plans. Let me conclude by congratulating all the speakers who are selected as a way of tribute to the role they played in shaping the African human rights architect. To Professor Franz in Center for Human Rights, Me Colette, the Human Rights Institute of Southern Africa, your support for the work of the Commission and the critical role in strengthening this instrument is well acknowledged. Congratulations to the African commissioners for ensuring that the work of the SAHRC does not go unnoticed through the progressive decisions that have been taken. There were times that we were always worried that those decisions were going to be overturned as reports were submitted before the African Commission during the AU sessions. However, the determination by commissioners such as Commissioner Pansy Tlakula, whom I'm quoting because I was there during her time when I was serving in the commission, made sure that these decisions were never rolled back. The role that civil society played, led by yourself, Prof. Franz, and Mekolede, and other member leadership of the civil society, which I'm not mentioning, is very critical and should continue as we celebrate this 40th year. I thank you.
Thank you very, very much, Caron, for sharing that personal histories with us and also drawing links between your own personal experience and the work, the advancement for human rights of the African Commission on Human People's Rights, and particularly focusing on women's rights issues where the Commission played a particular and important role. We also thank you, Caron, for being with us today in your capacity also as director at DIRCO, but also, we wish you all the best for a full and speedy recovery, and we really appreciate your honest and candid, personal reflections also about and around COVID-19. So thank you so much for being with us and sharing those thoughts. It appears that Judge Nsebeza is not linked to us. We hope he's not on a different platform, but we wish him obviously all the best. Our newly elected judge of the African Court on Human People's Rights. He's starting his term. It should run until 2017. I think he doesn't need much introduction. South Africans will recall that President Mandela in 1996 appointed him as one of the commissioners to the South African Truth and Reconciliation Commission, and he serves and has served as an advocate SC in many important cases in South Africa. So we trust and we anticipate that all of us in civil society and otherwise would have future opportunities to engage with Judge Nsebeza. We wish him all the best. So at this point, we turn to the questions and comments that had been made in the chat box, and we will invite some of our guests of honor perhaps to take the floor again. Now, Judge Ngoepe, the issue that has been raised is again Article 34.6 declaration. So the question is, perhaps you can just give some further insights around strategies or approaches to, in the first place, get states that have not yet ratified the court protocol, for example, in Southern Africa, a few states, to ratify the protocol. And then how does one go ahead? How does one argue? What strategies are there for getting states to make the 34.6 declaration? Judge Ngoepe, we would appreciate your reflections on those issues, please.
Thank you, Prof. Thanks for the question. I guess I can answer both in one breath. That is encouraging some states to ratify and also encouraging those who have ratified to make the 34.6 declaration. We remember that the 34.6 declaration is the declaration you make in terms of which you allow private citizens, private persons in your own country to cite you before the African Court on Human and People's Rights. What I have found to be effective is the pressure from civil society. There is a coalition. I think the coalition did a lot of work on the coalition on the work of the African Court on Human and People's Rights. And I think, of course, the kind of pressure that we can talk about is, of course, peaceful mechanisms to coerce those reluctant countries to ratify and or make the declarations. I think sometimes we underestimate the power of civil society. Properly harnessed, civil society is a powerful mechanism to exert pressure on politicians, because really this is a political question. It's not a legal question. It's a political question. It is politicians who must decide whether or not to make the ratification or the declaration. The other thing that could work, and I raised this one time when I was the vice president of this court, and we had a meeting with representatives of the of the European Union, and I said to them, you always say you're worried about the issue of human rights on the continent, but you always give financial support to individual countries on the continent, as also to the African Union. But what you never do is to properly link, as a condition of financial assistance, you don't link that to the issue of human rights. And one of the things that you should do is to say to any country to whom you award any assistance, financial assistance, to say, submit an audit of your respect for human rights. But in particular, coming to 34.6, I said, you need to say to them, in order to continue to get financial assistance from us, you need to consider seriously to making the appropriate declaration in terms of 34.6. I pertinently raised that issue in Addis Ababa. But of course, as I've said, these are political questions, and them being diplomats in their interaction with various countries, they would never do that because they are not, in my mind, sufficiently concerned about the issue of protection of human rights on the continent. And these are some of the mechanisms that we can use. There may be others, but these are some of the mechanisms that I thought we could employ.
Judge Ngoepe? Yes. So I think there's a small follow-up, if I may, and that is probing just the argument that South Africa and perhaps other states make, but particularly the South African argument against making the 34.6 declaration, at least at times, had been that we don't really need an African court. It is superfluous to make that declaration because we have a very, very progressive constitutional court in place. Would you give some reflection on the validity of that kind of line of argument, please, Judge Ngoepe?
It's not a valid argument. How then do you explain ratifying the protocol in the first place? You ratify the protocol that enforces the charter. You support the system halfway. You don't support it fully. Either the court is relevant or is irrelevant. It can't be half relevant, half irrelevant. So if you accept the authority of the court, do so fully, not halfway. You cannot ratify the protocol, accept the authority of the court, but then say, well, when it comes to individuals approaching that court, then I am not willing to do that. It's not a valid argument. We know what the real reason is. The real reason is that, which has been advanced by some people, is that they are worried that individuals might abuse the system and keep on hauling the country before the African court. But why would they keep on hauling you before the African court if you have a huge respect for human rights? If you don't violate human rights and you have no intention of violating human rights, what are you worried about? Why should you worry about? Police catch thieves and not law-abiding citizens. So if you have got a clean mechanism at home to protect human rights effectively, and you respect that national mechanism for the protection of human rights, why fear about being hauled before the African Court on Human and People's Rights? That court can never be irrelevant simply because you've got a national effective mechanism, because you take a narrow nationalistic view of jurisprudence. Jurisprudence is like a world economy, is global of application. you don't find the richness of jurisprudence only within your national mechanisms. The court like the African Court on the continent enriches your national jurisprudence. For example, there is a judgment that the court handed down with regard to the issue of criminalizing or not criminalizing defamation. I was party to the writing of that judgment. And to a certain extent, earlier on you mentioned about some of my dissenting opinions. There have been quite a few, but one of them, not necessarily dissenting, but one of the, I was one of those 2-3 judges who went further to say, in so many ways, that we must decriminalize defamation, leave it within the sphere of civil law. More or less around that period, there was a judgment in this country which fell short of what we said in that judgment in the African Court. It did not quite declare itself against criminalizing defamation. It didn't go far enough. And it didn't go far enough because it did not match up to the jurisprudence of the African Court on Human Rights. In other words, it was not that much enriched. That is where enrichment comes from. Enrichment comes when you go beyond your borders. Thank you. Maybe I shouldn't go too far about that.
Thank you. Thank you very much, Judge Ngoepe, for that very, I think, enlightening answer. The other issue I want to turn to is both, I think, the members of the Commission talked about the political interference, if you like, pressure from the African Union policy organs. So the question is, how can the independence of the African Commission and the court be strengthened to ensure that the African Commission discharges its duty as prescribed by the Charter, free from interference from the African Union political or policy organs? So I think we focus here on the Commission, given the particular history around the Coalition of African Lesbians and NGO observer status. And I ask perhaps first Commissioner Pityana, Professor Pityana, to address this question, and thereafter we will give Advocate Tlakula an opportunity. Barney, Professor Pityana, over to you.
Thank you very much. It is, of course, we all know, it's a matter of political will. And really, if we take the Constitutive Act of the African Union seriously, which does make it clearer than it had ever been the case, that there would be instances where national sovereignty can be overridden in certain cases. Now that's innovative in international law, and that would then be able to give the Commission, the AU Summit of Heads of State and Government, the opportunities in certain instances to address extra national questions. But that is a matter of political will. I don't think there is the political will in the continent at the moment. From the African Commission's point of view, we felt at the time, because the protocol of the African Commission was designed at the time I was a member of the Commission. From our point of view, we felt that once we could get agreement on the court and substantively insert the authority and the power of the court, many of those questions could be answered, because it would allow the Commission to go to the court for mandamus or a declaration or whatever it is in certain instances. We really did believe that we have an instrument outside of the Summit of Heads of State that can actually have the power to do it. Beyond that, it seems to me that there's very little that the Commission can do, because it is a matter of political will.
Over to you, Advocate Tlakula.
Yes, thank you very much for that question. As you know, that it's a question that we grappled with during my tenure at the commission. You'd recall that there was an attempt, there was in fact not an attempt, there was an application for an advisory opinion on that very question to the African court. Unfortunately, the African court dismissed the case on a technicality that the organizations that brought that application had no locus standi. But I still think that the question that was the advisory opinion that was sought from the African court can still be sought by the African Commission itself. The question being whether a political organ can actually instruct a treaty body to change its decisions. I think it's an important question. And I think it's a question that I still believe that the African court should assist the whole continent to interpret. But unfortunately, just before I could advise or recommend to my colleagues that we should bring in that application for an advisory opinion to the African court, my tenure came to an end. So I'm not sure whether this has happened. I've not been closely following the developments at the African Commission on Human and People's Rights. Thank you.
Thank you very much, Advocate Tlakula, for sharing that. I think regrettably we are running out of time. We've scheduled a certain period of your precious time. I can just mention some other issues that came up in the chat box, included women's rights to land, issues of racial discrimination, and the interesting issue whether there is a South African kind of fingerprint on the work of the Commission and the court. But I think these are issues that we can all ponder on as we keep being involved in the further growth of the African human rights system. So thank you very much for that. We will now take a small break, as it were. We will watch a short video around the history of the African human rights system with a focus on the African Charter. And we ask, please, that you don't go away, because in a sense, the highlight will follow thereafter. We will hand out also our virtual certificates to our guests of honor. So the video will now briefly play.
On the 27th of June 2021, it was 40 years since the Assembly of Heads of State and Government of the Organization of African Unity, also known as the OAU, adopted the African Charter on Human and People's Rights. The idea of drafting a document establishing a human rights protection mechanism in Africa was first conceived in the early 1960s at the first Congress of African Jurists held in Lagos, Nigeria in 1961, where the Law of Lagos was adopted. It called on African governments to adopt an African treaty on human rights with a court and a commission. However, at the time, African governments did not take serious steps to put this idea into practice. When the OAU was established in 1963, its founding treaty, the 1963 OAU Charter, did not impose an explicit obligation on member states to protect the human rights of its people. In spite of the absence of a clear human rights mandate, the OAU took bold steps to advance a number of human rights issues. It supported the right to self-determination with a view to full decolonization in Africa. The OAU also combated racial discrimination exemplified by its crucial role in the struggle against apartheid in South Africa. However, the Continental Organization ignored the massive human rights abuses perpetuated by some authoritarian African leaders against their own nationals. This was due largely to the OAU's prioritization of socio-economic development and its strict adherence to the principles of territorial integrity, state sovereignty, and non-interference in the internal affairs of member states. At the first conference of the Francophone African jurists held in Dakar, Senegal in 1967, participants again revived the need for regional protection of human rights in Africa. The United Nations also facilitated a series of seminars and conferences in a number of African countries. An ad hoc working group was set up to engage African heads of state on the need for an African regional human rights system. Subsequent to the committee's visit to Senegal, the then president of Senegal, Leopold Sédar Senghor, undertook to table a proposition before the OAU Assembly at its next session. In 1979, meeting in Monrovia, Liberia, the Assembly unanimously requested the OAU Secretary General to convene a committee of experts to draft the Regional Human Rights Instrument for Africa, similar to the European and Inter-American Human Rights Conventions. The decision of the OAU Assembly in 1979 to embark on the drafting of the African Charter was Africa's response to human rights abuses of the mid to late 1970s in Uganda, under the then President Idi Amin, Equatorial Guinea, and the Central African Empire under the Emperor Bokassa. When the incumbent heads of state in these three countries all lost power at that time, OAU leaders engaged in self-reflection about the OAU's failure to criticize the leaders of these states or intervene in any other. They therefore committed themselves to putting in place the African Charter as a bulwark against the recurrence of such atrocities and as a means to ensure that there would never again be OAU in action in the face of serious human rights violations in its member states. The Committee of Experts prepared an initial draft of the Charter. A conference of 20 African experts, presided over by Judge Keba Mbaye, was organized in 1979 in Dakar, Senegal. The work of the expert committee was greatly influenced by the opening address of the host president, President Senghor, who enjoined the committee to draw inspiration from African values and tradition, and also to focus on the real needs of Africans, the right to development, and the duties of individuals. In the midst of a polarized Africa, with some heads of state accustomed to autocratic practices which would be undermined by a human rights treaty, President Senghor's support was timely in promoting the drafting and eventually the adoption of the African Charter. As a result of the hostility of certain African governments to regional human rights protection in Africa, a conference of plenipotentiaries scheduled for Ethiopia to adopt the draft charter could not take place. Amidst this strained atmosphere, and at the invitation of the OAU Secretary General, the President of the Gambia, President Dauda Jawara, convened two ministerial conferences in Banjul, the Gambia, where the draft charter was completed and subsequently submitted to the OAU Assembly. It is for this historic role of the Gambia that the African Charter is referred to as the Banjul Charter. The adoption of the African Charter on 27th of June 1981 in Nairobi, Kenya, represents a drastic curtailment of the principle of non-interference in domestic affairs. After ratifications by an absolute majority of member states of the OAU, the Charter came into force on the 21st of October 1986. While the Charter was adopted 40 years ago, 2021 therefore also marks 35 years since its entry into force. Of all OAU or AU treaties, African Charter is one of the most widely ratified treaties. Today, 54 of the 55 African Union member states are party to the Charter. Only Morocco had not become a party to the African Charter. By the time it withdrew from the OAU in 1984, Morocco had not become a state party. Since its readmission to the AU in 2017, it has not become a party to the Charter, largely due to the contestation of the right to self-determination of the people of the Sahrawi Arab Democratic Republic, Western Sahara. The African Commission on Human and People's Rights monitors and oversees state implementation of the African Charter. It consists of 11 eminent African human rights experts. The Commission first met on the 2nd of November 1987. Its seat is in Banjul, The Gambia, which was inaugurated on the 12th of June 1989. The African Court Protocol was brought into being to establish an African Court on Human and People's Rights to complement the Commission's protective mandate. It entered into force in 2004. While the Commission's findings are of a recommendatory nature, the Court's decisions are unequivocally legally binding on states. The African Court on Human and People's Rights consists of 11 judges elected from African experts in human rights. The year 2021 marks 15 years since the first judges were elected in 2006 and the court started operating. Today, largely based on the African Charter and its influence within the African continent, human rights has been entrenched as a foundational principle of the African Union Constitutive Act and is central to the African Union.
We hope that created some background further to those who are not so familiar. By way of brief concluding remarks, myself and Colette will just have some thoughts, and then we will proceed to the handing over virtually of the certificates. I think for me, in the first place, one can say confidently that South Africa contributed to the development of the African human rights system. We've seen and we know that 3 very eminently qualified, prominent South Africans have served for significant periods of time with both the Commission and the Court, and that Judge Nsebeza will do so into the future. The second point for me that becomes very clear is that the work and the activities of the African Commission Court, these are not a moment fixed in time. They are important evolutions and developments over time. If we listen to Professor Pityana, for example, there's a reflection on how things started, the first decade, the second decade, and there is, I suppose, an expectation that the trend will be progressively, arc will bend in favor of justice. But from what we've seen in the last few years, there's a sense of being disconcerted that, in fact, the trend is not necessarily a progressive one. So I think what we know from our involvement with the system is that there is reason, there is cause for vigilance, and civil society clearly needs to work together with and support the Commission and the Court. The same, in a sense, applies to South Africa as a government and its involvement. It nominated very good people to serve on these bodies, but if we look over time, there perhaps had been also ebbs and flows. I actually consulted the activity reports of the Commission and found, in the context where Caron comes into play, the 24th activity report of the Commission for the years 2007-8 shows that South Africa donated $270,000. Now, at the time, a significant amount of money. And South Africa was more invested in the future, I think, at the outset of the development of the human rights system. It's our cumulative challenge to see how can we rekindle that kind of enthusiasm also on the part of the South African government. Colette, over to you for one or two of your concluding reflections, please.
Thank you very much. I think what I'm taking home is that 40 years of adoption of the African Charter really is a big period of time of delivering political, civil, and economic and cultural rights that are safeguarded in the Charter. And those questions about the impact of the Charter, how has the Charter changed lives of peoples in communities, are very relevant questions. The legacy that is left by our prominent brothers and sisters in the continent, I think it's not in vain. I think all of them, they have expressed the lack of political will on part of the government to support and to implement decisions of the African Commission. And also the power of the civil society, as Justice Ngoepe has said, that we should not underestimate that. And as long as we can consider to be properly harnessed, it means we need to restructure our frameworks, our strategies, because we now know where are the stumbling blocks. The stumbling blocks is the charter itself is created in such a way that it limits, it does not provide the Commission leeway to achieve much. And as a civil society, we need to continue working together, uniting and becoming robust to make the mechanisms of the African Commission effective and work. And as for the advisory opinion, as Advocate Pansy has mentioned, that who has got access, who's got local standards to approach the African Court, it is still give us the impression that the Commission can use its mandate to interpret the court, the African Charter, in order for us to know that are we having this opportunity to request the African Commission to interpret the African Charter on Human and People's Rights. I want to leave it there with words for all of us, the government, Department of Justice, Department of International Relations. Your absence here is really missed. You miss an opportunity to engage and to see how we improve in promoting the African Charter in South Africa. And national human rights institutions, we need to find a way of strengthening our collaborations. We do Africa Human Rights Day. That is not enough. Many people still remain unaware of the mechanisms. So I hope that we continue doing this work, not only targeting days like this, celebratory days like this, but use opportunities within our powers to make the mechanism effective and realizable. I thank you very much.
Very much, Colette, for those concluding remarks as well. Now, we come to the virtual handing over of our certificates. We promise that somehow we will get them physically printed and signed to you. So on this occasion, the 40th celebration of the date of the adoption of the African Charter on 27 June 1981, we honor, we thank Barney Pityana, first of all, who has worked tirelessly and passionately to advance the promotion and protection of human rights on the African continent when he served as a member of the African Commission on Human and People's Rights from 1997 to 2003. Thank you so much for being with us and receive our gratitude and thanks. Secondly, Advocate Pansy Tlakula, who has worked tirelessly and passionately to advance the promotion and protection of human rights on the African continent when she served as a member of the African Commission, and that was from, to correct myself, 2005, yes, to 2017. That is for a term of 12 years with the African Commission, and she served also as a chairperson of that commission for the last stint of 2015 to 2017. Thank you for honoring us with your presence and with being with us here today. We will get it to you personally. Judge Bernard Ngoepe, who has worked tirelessly and passionately to advance the promotion and protection of human rights on the African continent when he served as judge of the African Court on Human and People's Rights from 2006 to 2014, including as its vice president between 2013 and 2014. Over to Colette to do the other certificate. Thanks.
This one certificate is for Mampurani Caron Kgomo, who worked tirelessly and passionately to advance the promotion and protection of human rights on the African continent when she was seconded by the South African government to serve as an assistant to the African Commission on Human and People's Rights, Special Rapporteur on the Rights of Women in Africa. and provided technical support to the Secretariat of the African Commission on Human and People's Rights between 2007 and 2011. Thank you very much. You will receive the certificate. Caron.
Thank you very much, Colette. And my last words, brief words of thanks, sincere thanks to all of you, the participants who listened in, who also thought through the process that we're engaging with today. Thank you for sacrificing, giving your time also to this important topic. Thank you very much to our partners, HURISA, Colette, my sister, thank you very much for working with us so well. Also the South African Human Rights Commission, Philip Mukwena, who was really the man behind the scenes, who made it all possible from their side, but also Tseliso and Advocate Majola. We thank also very much all the speakers who presented, was represented here, in particular our guests of honor. It was really because you were able to be here that this occasion was endowed with splendor and with much deeper meaning. Thank you so much for doing what you have done and also for being with us today. And lastly, also to the technical people involved, Louis Kluter Productions and all the people that made this seamlessly appear so easy to run, but obviously if something goes well, as they say, it's a team that makes it so, and on our side at the center, also Yolanda Boyson and others who assisted. Thank you to you all. We will end off again with the playing of the AU anthem, and that will, I hope, inspire us all further to reach out for the stars as far as the evolution of the African human rights system is concerned over the next 40 years and beyond. Thank you.